everyone. My name is Sonam Narayan and I'm currently pursuing BA LLB from University of Petroleum and Energy Studies. I'm in my fourth year and I'm interning under LEXIS and Company. And in this video, I will be talking about the mandatory bail. I will be dealing with the important and relevant section which governs the provisions of the mandatory bail in the Criminal Procedure Code 1973. So the section 167 uh, says that and gives the judicial magistrate the power to authorize custody of an accused person in cases wherein investigation cannot be completed in 24 hours. So it gives the judicial magistrate to authorize the custody of an accused person whose investigation cannot be completed in the span of 24 hours. All right. So it provides for the maximum period of custody that can be authorized. It states that and it mandates that if the investigation is not completed within the stipulated maximum period, the accused is to be released on bail, whatever may be the nature of accusation against him. Now, section 167 clause 2 says that the magistrate to whom an accused person is forwarded under this section may, whether he has or has no jurisdiction to try the case from time to time, authorize the detention of the accused person in such custody as such magistrate thinks fit for a term not exceeding 15 days in the whole. And if the magistrate has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, what he can do is that he may order the accused to be forwarded to a magistrate having such jurisdiction. Now, provided that first the magistrate may authorize the detention of the accused person otherwise than in the custody of the police beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so. But no magistrate shall authorize the detention of the accused person in custody under this section for a total period exceeding 90 days where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years. All right. And in the cases where the accused person shall be released on bail if he is prepared to and does furnish bail, then in that case the time period will be of 60 days where the investigation relates to any other offense, and on the expiry of the said period of 90 days or 60 days as the case may be, the accused person shall be released on bail if he is prepared to and does not furnish and does furnish bail, and every person released on bail under this subsection shall be deemed to be so released under the provisions of chapter 33 for the purposes of that chapter. Now, in the case of Rakesh Kumar Paul versus State of Assam, the court held that the offences punishable with imprisonment of not less than 10 years have been kept in one compartment, equating them with offences punishable with death or imprisonment for life. Now, this category of offences undoubtedly calls for deeper investigation since they provide for a lesser minimum sentence, even though the maximum punishment could be more than 10 years imprisonment. In the case of Suresh Jain versus State of Maharashtra, the Supreme Court held that a person accused of an offence acquires an indefeasible right to be granted bail on meeting the bail conditions if investigation is not completed within the periods mentioned in section 167 clause 2 of CRPC. And the magistrate is mandatorily required to release the accused person. Any detention beyond the prescribed period would be illegal. Now, in the case of Fakhre Alam versus State of UP, the court held that the default bail under first proviso of section 167 clause 2 of the Code of Criminal Procedure is a fundamental right and not merely a statutory right. Now, in the case of ADM Jabalpur versus Shivkant Shukla, which is also known as the habeas corpus case, the court stated that the human element in the life of the individual is integrally founded on the sanctity of life. Dignity is associated with liberty and freedom. No civilized state can contemplate an encroachment upon life and personal liberty without the authority of law. Neither life nor liberty are bounties conferred by the state, nor does the Constitution create these rights. The right to life has existed even before the advent of the Constitution. In recognizing the right, the Constitution does not become the sole repository of the right. It would be preposterous to suggest that a democratic constitution without a Bill of Rights would leave individuals governed by the state without either the existence of the right to live or the means of enforcement of the right. Now, the right to life being inalienable to each individual, it existed prior to the Constitution and continued in force under Article 372 of the Constitution. Thank you.